right. I think you're here luckily or unluckily on this docket because of disqualifications. Are you planning to proceed today?
Yes, Your Honor.
Yes.
Okay. Would I double checked with the court? Did both of you intend to file temporary orders?
I did not.
Oh, okay.
No, we've been kind of getting away from that just because they're so subject to change that we're essentially doing it twice. So we've kind of gone back to the old pattern of we get the court's ruling, draft the orders, and then set a presentation for 2 or 3 weeks out. That was kind of my intent with that.
Perfect. Okay, great. I just wanted to make sure I wasn't missing something. I saw the documents and reviewed them online. I just wanted to make sure I had everything. How much time do you think you all will need for presentation of your statements to the court on this one? I'm just trying to figure out where to put you, and I don't know if you both have to be on other dockets.
I don't have any other dockets. I can be as quick as you need us to be, Judge. If you feel like you've got a good grasp on everything and reviewed everything, then we could probably, at least speaking for myself, be pretty brief. If you have questions or need further information, 15 minutes apiece, maybe.
Okay.
I think that's accurate. I kind of figured we'd be at the end of the docket, but I'm happy to do whatever the court would like.
Okay. Yeah, as long as you both don't have to jump off for another docket, if you don't mind, I'll probably call you first or second to last. I think there's one other case that might take a little while as well. So I'll check back with you here probably in about an hour. So if you want to log off and log back in at 10, feel free.
Okay. I will do that. Thank you.
Okay. Yes.
I'm literally in court.
Okay, if you are not actively in front of the court, please mute yourself.
I'm here, Your Honor.
Okay.
I'm here as well.
And sir, are you able to turn a camera on?
I'm working on it right now. I apologize.
Okay. 00360 Lucas the Shock and Tiffany the Shock.
If someone is running YouTube on a different screen, we're getting some feedback from that. So close that out, please. Okay. Okay, so when we were here at last on November 15th, we did have a service issue for the adequate cause motion. I did temporarily reissue the restraining order, but I set both issues over to today to address. Since November 5th, since our last court date of October 25th, I have received the amended proof of service on Mr. DeShock, noting a party over the age of 18 gave the documents directly to Mr. DeShock on October 21, 2023. And then I did also receive a filing from Ms. DeShock, which included a copy of the criminal pretrial no contact order. Is there anything else that the parties have filed recently since our last court date that I don't have?
No, Your Honor.
Okay. Ms. DeShock?
No, just the forms that I filed with the no contact order.
Okay. And then, so what I need to do first is make a decision on the adequate cause motion. The adequate cause motion is requesting me to find that there's been a substantial change that would warrant changing the parenting plan that's been in place. By my understanding, there has been kind of a new issue between, and Mr. DeShock certainly don't speak to any pending criminal matters, but there has been a new issue between a minor child and you, sir, Mr. DeShock. Yeah. So let me ask you first, sir, are you objecting to the parenting plan being changed? And I guess I ask that in light of the fact that I do know that there is right now a 5-year criminal no contact order in place.
Correct. I haven't exhausted any of this. I'm out on bail on those charges, and I would like to just change the custodial parent and just have Adriana stay at the house with her mom and we can let the state know she can start getting child support. And obviously, I'm not going to talk to her for 5 years, or at least until this court proceeding is taken care of.
Okay. So it sounds like you're not, for now, you're agreeing that given the way things are currently situated in life, you are not objecting to me finding that there is adequate cause to at least temporarily change this parenting plan. Is that right?
I'm requesting that we don't change the parenting plan until my other case is resolved. I'm asking if we just continue with the no contact order that's in place, and and I'm sure Tiffany would like to get some money from the state going, and then we could just wait until this is done, and then we can address the parenting plan.
So you are arguing that this new pending criminal charge is not a significant change in your situation and thus doesn't warrant a change in the parenting plan?
Not at this time.
Okay. Ms. DeShock, what would you like the court to know about your request asking me to find adequate cause to change a parenting plan?
I feel like there's more than enough adequate cause at this point. I mean, there's a 5-year no contact order, and unfortunately, this is not the first occurrence to where Adriana has been down at the police station in Centralia due to abuse from Lucas. Happened previously, but she had ran away and there wasn't enough markings for them to take her out of the home. And so with this last incident, with everything going on and the 5-year no contact order, I feel like it is in her best interest for the parenting plan to be changed. And that way I can also get her enrolled in school down here where she's living. She's doing much better down here than she has been. And I feel that it would be in everybody's best interest. I mean, a 5-year no contact order is kind of something important to be holding off on.
Okay, so I'm just, first of all, I will, in talking about the adequate cause finding, I do think that pending criminal charges between a petitioner and his minor child meet the definition of a substantial change that warrants this court revisiting the parenting plan. So I'm going to note that I am finding adequate cause to revisit the parenting plan. I will find that this court has jurisdiction over the child. I have to make a couple changes to your proposed order. Do you have whiteout up there?
No. Let me look at your criminals that you've already done.
Please mute yourself. If you're not actively in front of the court, please. So what I'm going to do, I would say, Ms. DeShock, I do have a proposed parenting plan that you filed on September 26th. Is this still the parenting plan that you're asking the court to consider?
So I actually gave him when he was served, he got all of my copies of the paperwork. Okay. If I remember correctly, I was just asking for it to be switched over to where she is with me. And I believe I even put with supervised visitation for Lucas. And I know I didn't ask for any child support or anything like that. The only thing that matters to me is that she's, here and safe.
Yeah. So, and do any of the kids between the two of you receive any sort of state assistance like medical benefits?
Adriana does through me now. I get food benefits for her and she gets health insurance benefits through me.
Through the state. Okay. So what I'm going to do, because the problem with the proposed order you have filed, there is a no contact order in place. So I can't give supervised visitation at all.
When I filed that, there wasn't a no contact order.
I'm not asking for any visits.
He was,
I understand,
he was in jail at the time.
Okay.
And so I didn't know there was going to be a no contact order. It was just, everything happened on a Friday. And then the following Tuesday, I had a non-refundable trip that was already all paid for. And so to make sure she was safe while I was gone, that's why we went ahead and did the emergency restraining order, just to be on the safe side. And they told me to make sure I turned in the adequate cause and everything all at the same time. And so not knowing that there was going to be a no contact order, that's why I put in there for the supervised visits, just because of, the abuse factor. I didn't want there to be any chances for that. But
Okay.
with there being a no contact order, I completely understand that he can't have visitation or any communication or anything.
Yeah. So what I am inclined to do, because it sounds like Mr. DeShock, you're in agreement for now on a temporary basis, at least for Ms. DeShock to be the custodial parent.
Yeah, I'm not disputing that.
Okay. So what I'm going to do is kind of clean up your proposed order of parenting plan. I'm going to file it as temporary. So I'm just essentially going to have to start over and print off a new parenting plan. But I'm going to call it temporary for now, which means at some point you all will have to come back and work out a permanent final order parenting plan. Ms. DeShock, you're going to want to take once you have the temporary order in hand that gives you 100% of time with kiddo, you are going to need to file that with the prosecutor's office so they can determine child support. They may have you come back on this docket to discuss what the child support order looks like if there is disagreement.
Okay.
Okay.
Now,
Go ahead.
I also gave the courts the only copy of the no contact order that I had received. I know it said that the police department needed to be served with a copy of that. Do I still need to serve the Longview Police Department down here with a copy? Or because they already have it in the system, do I not need to file it with them?
Are you talking about the Lewis County Municipal Court? So
that no contact order.
Yeah, I can't give you legal advice on a different court's no contact order. So if you have questions about that, reach out to the prosecutor in Lewis County or the municipal court in Lewis County. Okay.
Thank you.
And then I'm going to get that order on a temporary basis filled out. It'll probably be ready for you by end of week, by Friday, if you both want to get a copy of that. Do you have any questions for me? I am going to be adopting the September 26, 2023 temporary order that Ms. DeShock proposed, but I will be making changes to supervised visitation. I'll be taking that out, obviously, given the current no contact order and the pending criminal charges. And then when...
Excuse me, I do have a question when you're done.
Go ahead. Go ahead.
So the temporary restraining order between me and Tiffany, is that going to be lifted? So I can... I was trying to get a hold of for some other stuff, but
yeah. So Ms. DeShock, the temporary restraining
is it still with Ms. DeShock?
So let me just ask you, Ms. DeShock, the temporary family law order was, I think, kind of your most important reason for doing it was to protect your minor child. Are you wanting the temporary order in the family law case to remain in effect that keeps any contact from occurring with you?
I mean, him and his wife share a child, which is Adriana's half sibling. So, I mean, if it'd be possible for me and Mr. DeShock to be able to communicate and maybe try to work things out to where she could, still see her siblings, things like that. I have absolutely no problem with that restraining order being lifted.
Okay.
As long as she's the one who's protected, I don't at all.
Okay. So what we'll also do then is I will let then the temporary order, which lapses today at this hearing, I will let that remain expired. So there is no longer a restraining order between the two of you, but obviously there is still the Lewis County no contact order between petitioner and minor. Any other questions for me?
So you did say it was temporary. I mean, assuming that's because we don't know what's going on with Mr. DeShock's criminal case.
Correct.
And so are we basically just kind of up in the air until we hear more on that, or would there be a date set?
You all would be responsible for noting back on when you feel you're ready for a permanent parenting plan.
Okay.
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 So yeah, no future date set.
The one that's in place. Okay.
So yeah, the temporary restraining order is going to be gone, but the 5-year no contact order is going to stay in place, correct?
Correct.
And then until his stuff is settled or one of the two of us feel that we can go to court for the permanent order, then that's on us to do. Like Absolutely. You guys aren't setting anything ahead of time. It's when we're ready for it, then we do.
Correct.
Okay.
And keep in mind, because a lot of people don't know the great resources we have, when you are ready for permanent orders, you fill those out. You meet with a courthouse facilitator here in Cowlitz County. They make sure that you have all your orders in place and ready for my review, and then you note it on. There's also mediation services available if you all get to that point. If you're in full disagreement, then we can set it for trial. So a lot of options available to you folks. But it sounds like you both probably will want to see how the underlying case plays out.
I would prefer to see that happen.
Okay. All right. Thank you both. You're both free to log out. And then I did see Tiffany. There you are, Ms. Steinweg. Thank you. So, Mr. Olson, are you able to unmute?
There you go. Sorry.
Okay. So, Mr. Olson, we missed you at the last appearance. What happened?
You know, it figures. Well, we are seeing the mediator. I thought we were supposed to see the mediator before we had court. I apologize.
Did you all end up going to mediation?
Yes.
Okay.
We still have one more session to do. And also I was just informed that my hair follicle results are back. So
Yes, they are, and I have reviewed them.
okay, cool.
Yep. We'll talk about that in just a minute. Ms. Steinweg, what update do you want to give the court regarding mediation?
I feel like a little bit of progress was made in communication. However, I don't feel like we will come to an agreement as he's not willing to give up any time or make any changes to the parenting plan.
Okay. When's your next mediation scheduled?
Tuesday, I believe.
Okay, Tuesday, November 21st. Okay. Are you, Ms. Steinweg, planning to attend that mediation?
If we don't make any changes today, yes.
Okay. Well, here's what I want to say. And Mr. Olson, you have to understand, especially with your lack of appearance, this has been a long process for Ms. Steinweg to show up and have you not be here and then show up. I am going to request that you both attend the mediation on November 21st, but I am going to give you, Mr. Olson, some pretty specific kind of guidelines that I would like you to consider as you go through that mediation. I understand that currently you are not wanting to budge at all on the parenting plan. But I am looking at your hair follicle testing, and I am telling you that it does not look good for you. Okay. What that means is you have a choice here to work with Ms. Steinweg in mediation and give a little, or you both are going to end up back on my next docket on a contested parenting plan. And based on this hair follicle testing from October 19, 2023, there are several positives of different substances. So I would be, in all candor to you, Mr. Olson, and I hope this gives you a reason to really work in mediation on giving a little. The things that you are popping as positive for are types of substances that absolutely give me concern for the safety of a child being with you. So please take that information and give mediation on Tuesday, the 21st, you're all. Because I am telling you, what I am seeing is troubling for the safety of your child. Okay?
Okay.
So you may need to give a little more than you might otherwise want to. And that's the purpose of mediation, is to come to a compromise with Ms. Steinweg. But again, if you can't come to that compromise, I'm happy to look at the facts that are now in front of me and make that determination myself. Okay. But there will be limitations. If I was making this decision today, there would absolutely be limitations on your parenting given the significant positives on this hair follicle test and the types of substances it's positive for.
Okay.
Okay. So you all mentioned the mediation is on the 21st. So Ms. Steinweg, I'll give you kind of first choice since I know you've been here multiple times. I could squeeze you in next Wednesday, the 22nd.
I would prefer to do it as soon as possible.
Okay. Mr. Olson, would you be available next Wednesday, the 22nd at 9 a.m.?
Yes.
Okay. So I am going to move you over to that date. And like I said before, it is in your best interest to really, truly, in mediation, let them mediate, let them help you come to a compromise. But if you don't, the very next day, I will make a decision on those things based on the evidence I have in front of me. Okay?
Okay.
All right. Any questions for me today?
I have a question.
Yes.
So with the information that you have, am I able to keep Zach until we go back to court next week so that we can make some changes then? Or
Yeah. Is there currently visitation happening with Mr. Olson?
oh yeah, he gets him every weekend unsupervised.
Okay. So Mr. Olson, I am going to cancel. I'm going to do Mr. Olson.
Yes, Your Honor.
Okay. I am Mr. Olson. Hold on. I am issuing a bench order that suspends visitation this weekend until our next court date because of my significant concerns over child safety, given your positive hair follicle testing for substances that I would call potentially fatal if a child came anywhere in contact with them. So I am going to be issuing that bench order, and I'm making an oral ruling here from the bench that there is to be no visitation until we come back on the 22nd. There can be phone, I will allow phone visitation,
Okay.
but there's to be no in-person visitation.
Okay.
Okay. All right. Thank you both. We'll see you back Wednesday. Please give mediation your all.
At 9 o'clock.
9 o'clock. Yes.
Okay. Thank you.
Thank you. 9. Do we have Mr. Conover present? Okay.
Yes, Your Honor.
Oh, there. You're in the iPad booth too now. Okay. Thank you. All right. Let me just jump into your file here. So I don't think I've had the two of you in front of me before. So let me just make sure I have a general understanding of what the parties think they're here for. It looks to me like there was a parenting plan action started in 2016. And ultimately, there was a final parenting plan, it looks like to me, August 31 of 2016. And you all have been working off of that parenting plan for some time. Now we find ourselves in a situation where Mr. Conover is seeking to, he's filed a motion for me to find adequate cause to change the parenting plan. And Ms. Adams, you've received that motion?
Yes.
Okay. Did you receive his proposed parenting plan?
Yes.
Okay. And then you filed a response disagreeing with the request for either major or minor change. You filed some declarations with that. Mr. Conover, have you received Ms. Adams' response and declarations?
Yes, I have, Your Honor.
Okay. And then Ms. Adams herself has proposed a parenting plan. Have you received that as well?
Yes, I have, Your Honor.
Okay. So let me start with maybe the easiest question, but the minute I say it, it probably will not be. You both have submitted new proposed parenting plans to me. Does that mean that you both agree that there is adequate cause to revisit the parenting plan from 2016 and you both want the court to do that? Or is this a situation more, Ms. Adams, a question for you? Did you propose a parenting plan just in case the court decided there was adequate cause to review this?
That, yes.
Okay. So Ms. Adams, are you still objecting to any sort of adequate cause finding to change
on his part? Yes.
Well, So on any part, are you asking for the 2016 parenting plan to change?
Yes.
Okay. And then Mr. Conover, you are also asking for the 2016 parenting plan to change, correct?
Yes, Your Honor.
Okay. And both of you are asking for it to change based on, I guess, locations where each parent is, it sounds like. Is that right?
Yes, Your Honor.
I would agree to that.
Okay. So I think what makes the most sense then is that you all are in agreement that there's adequate cause to change a parenting plan, and you both are jointly asking the court to change a parenting plan. You just disagree on what that new parenting plan should look like.
Correct.
Okay. So what I'm going to do is fill out the proposed order on adequate cause, and I'm going to state that you agree that you both agree that there are valid reasons for this case to move forward, that we do have jurisdiction, that the court can decide this matter. There is adequate cause to hold a full hearing on the petition, and the parties agree that there's adequate cause to do so. Having now found adequate cause, typically what we would do is set because you guys are in disagreement on what the parenting plan should look like, we would set you for a hearing on just the new parenting plan. Okay, so I won't be deciding that issue today, but we will set you for a hearing on the parenting plan. The other option I can give you is sending you all to mediation if you want to try that first to work on a parenting plan. Does anyone feel like mediation would benefit them as you guys go through this?
I think both of us are just in disagreement.
Okay.
I'm wanting more, he's wanting less. I don't think mediation.
Excuse me, Your Honor.
Yeah, go ahead.
Sorry to interrupt.
No, you're fine. Go ahead.
I'm willing to compromise on some things after reading Ms. Modisit's proposals.
Okay.
Just wanted to say that.
Okay. Well, it sounds like there might be some wiggle room here, Ms. Adams. Based on that, what are your thoughts about trying mediation? If it doesn't work, then, you're no worse off. You come back and we get you a hearing date.
I'll give it a try now that I heard his response.
Okay. I think that's a great idea. So let me just get that. I'm going to put transfer to mediation before setting for trial. So with the mediation, it is a situation typically where I have folks pay for mediation 50-50. It's not expensive, but depending on your income, the Mediation Services Center has programs for low or no cost mediation. So when they get a hold of you to schedule, and you can't pay it, they will work with you. So it's not a situation of you can't pay, so they won't see you. Okay. It is a community resource. So I know they really work with people on this. It'll be through Community Mediation Center. Ms. Adams, the address and phone number on your recent documents, are those still correct?
Yes.
Okay. Get those filled out. And then Mr. Conover, is the information for your address and phone number on your filings recently the same?
Yes.
Okay. Okay, I'm going to transfer you to mediation. I have found adequate cause. When you go to mediation, you will be dealing only with what a new parenting plan should look like. If mediation is successful, they'll send a certificate to me showing that mediation was successful and you all are ready for me to sign an agreed parenting plan. And so you guys would just come back to court and find a good date that works on a Wednesday at 9 a.m. for me to review that. If it's not successful, then, and you guys don't come to an agreement, that's fine. One of you will just note on for docket, actually, you would go to the trial assignment docket to get a trial date for your new parenting plan. Okay.
Okay, Your Honor.
I know it's kind of clear as mud when you haven't been through this process before. Do you have any questions for me about what comes next?
Not at the moment, Your Honor, no.
Okay. So you should be getting contact from the mediation center and they'll set a date for the two of you to show up.
Okay.
Okay.
Okay, thank you, Your Honor.
Thank you. Thank you both. Mr.
I'm here,
Swenson,
Your Honor.
Mr. Swenson, good morning. And Alonza Taft, are you there?
Yes, I'm here.
Okay. And is Michael Taft with us? Okay.
Yeah, I'm here.
There you are. Okay. So, Mr. Swenson, I apologize. I was going to check in with you before docket since this did get set on the unrepresented docket. And I think because of your appearance, you have been on Judge Evans' represented docket. I know he's the one that heard the motion to vacate. I did see his decision on that. Would you be asking for this contempt motion to go back to the represented docket, or do you want to proceed today?
We filed a responsive declaration on Monday. I don't know if Ms. Taft has seen that yet. We emailed it and mailed it to her.
Your Honor, I didn't get the response to this. The only thing I've gotten is the proposed order, which was signed for it to vacate the spousal support. But according to, from what my knowledge, the judge said that Michael is to pay the one-time repayment reimbursement of the $3,113. And so I filed the contempt and the motion strictly on the repayment that the judge told me that, and also told his lawyer that Michael still has to pay.
Yeah, hold on, Ms. Taft. I saw all of that. I reviewed what Judge Evans did. The question right now, though, is that you filed this new motion for contempt just on the $3,113 or something like that, that the judge still kept in the divorce decree. So I understand that piece. My question, though, is that Northwest Justice Project through Mr. Swenson did file a declaration of Michael Taft with an affidavit of mailing to your home and email on November 13th. Did you get that declaration?
Yeah, I'm sorry. I didn't hear. I couldn't, for some reason, the tablet tuned out.
Okay. So my question was whether you received the response declaration of Mr. Taft that was sent to your email on November 13th.
For the contempt, no, I did not receive it. Unless he sent it to a different email, but I haven't received anything. The only thing I received was the proposed order that was signed by the judge regarding the spousal support being vacated.
Okay. And so on Monday, this response was sent to you by mail and email. Would you like to review that before you proceed today?
No, I just want to proceed because I feel like not only have the judge granted again for him to pay that $3,113 back, he's already got the spousal support vacated, and you know he's got one thing to pay, which is that one reimbursement that he stole from me, and then we're done. So I'd rather just proceed. And the reason why I filed the contempt is because since I was granted for him to pay that back, it's been a long time, you know, from all the way of when the order was signed on the 14th of April. And we're already almost at the end of the year and he still hasn't paid nothing, made no efforts whatsoever. So I just want him to pay that back and we can be done with this.
Mm-hmm.
I mean, crazy.
We're ready to proceed today, Your Honor, on the contempt.
Okay, you are. Okay.
You've reviewed everything.
Yeah, let's go ahead and do that. So Ms. Taft, I do understand your argument. I did go back and look at Judge Evans' ruling on the underlying divorce decree. I do understand that he kept in specifically that $3,113, if I'm not mistaken, amount. But I do understand your argument. Is there anything else you want the court to know on your motion for contempt?
Well, yeah, because Michael had had plenty of opportunities to pay it back or make efforts to make that payment, but he chose not to make any of that payment. So, and we've come so far along in this case that I'm just to the point where something either he needs to pay or he needs to go to jail or something, following the court orders, because this is the second judge that agreed for him to have to pay that, and then all of a sudden now he's not paying it.
Okay, Mr. Swenson, go ahead.
Thank you, Your Honor. For the record, Stephen Swenson for Michael Teft. As Ms. Morris Teft pointed out, there was a judgment granted in this decree of dissolution in April of this year. But Mr. Teft has been unhoused for a year now. He's living in his car when that judgment was granted. Ms. Alonzo Teft has a judgment against him, which is accruing interest, but he is unable to pay it. Contempt is for those who are willfully disobeying an order. We also have due process protections in the Constitution that protect us from the debtor's prison. Mr. Teft was living out of his car in June of this year when the contempt for jail time was ordered against him. He was not represented at the time, which I believe was a procedural oversight, and he served 5 days in jail already. Ms. Teft was awarded his Jeep, which was not part of the original divorce petition because he didn't own it until after they separated. There's allegations that she slashed his tires while he was living in his car, and that she poured sugar in his tank. He lost his job while he was serving in jail. He receives $417 of ABD each month, and he currently has $150 to his name, no bank account, no car, and he lives in Hope Village. So he can't pay, he can't squeeze blood from a stone. If he ever does get money, she has a judgment against him, she can go after him, but currently he has nothing. So he begs the court not to find him in contempt and throw him back in jail.
Your Honor, if I may,
Go ahead.
Michael, when we got the divorce signed, Michael was working, as he told you before, and he could have paid, and he did have a car. He had the Chevy and I had the Jeep. This allegation to me, I think that's just some BS that he's trying to use his way of trying to get out of this, just like he tried to use his mental illness to get out of the whole spouse support, which worked in his favor. And to be honest, he stole that money. I've showed proof that he took the money got deposited in his account. I feel like he's trying to say, oh, he's homeless and that, and say he can't pay it. But when he had an opportunity to pay payments, I tried to work with Michael. Michael chose not to do none of that. So I feel like this is just an excuse for him to try to get out of not having to pay anything. He's already got out of the spouse support. I feel like he shouldn't be able to get out of this because I've showed actual proof that holds the 7,000 it was. I showed the proof that when he also had a protection order on me, then kicked me out the house and I was on the street and he got that money and didn't care about me being on the street, not having nowhere to go or any of that. And then all of a sudden now he wants to try to say, oh, I'm homeless, I can't pay for anything. But yeah, he's getting money. He's going to the casino. I've been getting his little casino stuff to the house that's been coming to our address or where he used to stay at. I've been telling him to change his address because I still get his mail. He's have bank cards. I have proof of bank cards that he has saying that he don't have an account. He does have a bank account. That's a lie right there. Slide again.
All right, Ms. Teft, hold on. I've heard enough. Thank you. Here's what I'm going to do, and in being very familiar with this file and now having gotten up to speed on Judge Evans' ruling on the order to vacate, other obligations, but keeping in the obligation to pay $3,113 that was due within 30 days from when the court order was signed. I am going to find Mr. Teft in contempt of that obligation. The court was very specific that that's an obligation that remained. I do believe that the records show that he would have been able to pay it at the time that it was due. I understand his circumstances may have changed now, but I do believe that he was able to make that payment. I believe he still is able to make put together a payment plan for this money. The contempt I'm ordering is not jail time. I have specifically crossed out that request, and I have indicated jail time does not apply. I am granting contempt for the principal amount plus 12% interest. This contempt may be purged if Michael Teft makes a payment plan towards the repayment of that amount. And I'm going to give a review date of December 13th, 2023. So just about 30 days for a payment plan to be put together. Also, contempt can be purged, which means corrected, if he has proof that he paid it back previously, as he has suggested in multiple pleadings throughout this case. So under either scenario, we will review any payment plan or proof that it was paid back previously when we return on December 13th at 9 a.m.
Also, Your Honor, if I may,
Ms. Taft, hold on. Are there any questions about my ruling?
Are you gonna order a payment plan, or are you expecting us to negotiate one?
I would like the
Or propose one?
I would like the parties to propose a payment plan. Ms. Taft, go ahead.
Oh, I was gonna say I can show proof that I did submit documents showing the date that he had got a protection order on me after he had me assaulted by his baby mama, and I have a printout of the bank record showing that the money sits at his bank account too as well.
Yeah, so I'm not putting a burden on you, Ms. Taft, for new evidence. The judge already essentially sided with you that he believes that money is owed to you. What I am simply stating is Mr. Taft has two ways he can purge this contempt. He can make a reasonable payment plan with you and start making payments, albeit in small amounts, that's fine. Or proof that he paid that amount of money back. Okay, we'll see you all back December 13th at 9 a.m. Jeffrey Willis Hellam and Tiffany Hellam, if you are present.
Hello.
Okay, that's you on the Jeffrey's iPhone. Okay, see you there. And do we have Tiffany? Sir, what I am seeing is that you did file an order to show cause, but that it has not been served. I have noticed that the sheriff was not able to serve.
Yes, he's tried twice, Your Honor.
Okay. I only have one attempt filed. Do you know when the second attempt was?
No, but I can obtain that if you'd like, Your Honor. I called the sheriff's office, I think yesterday or the day before yesterday, and they said they've made 2 attempts with her not answering her door.
Okay. Well, the only problem I have too, though, is both of those attempts. So you have to, under our local rules, give someone 21 days notice of your motion. And you attempted to serve her on November 1st for November 15 court date, which we wouldn't be able to move forward even if she had been properly served. Okay. So I guess my proposal is, do you know where she is, or you just don't know?
Well, she's home all day. She works nights, Your Honor.
Okay. So
she's just not answering her door.
Okay. All I can do today, because there's no service, is strike the hearing. I would recommend that you renote it for a future date that gives you plenty of time for that 21 days to happen, and then try and get her reserved.
Can I ask you a question, please?
Sure. I can't give legal advice. I know a lot of people like to ask me legal advice, but go ahead. I'll tell you if I can answer it.
Does the sheriff keep trying to serve her, or how's this?
That would be a question for the sheriff. I really don't know, honestly. Check with them. You're also free to use any process server or unaffiliated person over the age of 18 to serve. So whoever does serve, it doesn't have to be the sheriff. Whoever does serve just needs to file notice of the date and time that they served and what they served.
Okay.
Okay, so I'm just going to go ahead and strike. Please renote and keep in mind that 21 days of service on her before the hearing date. Okay?
Your Honor, thank you for your time.
Yes, you're welcome. For review hearing, when we were here last on our court date of November 1st, Mr. Young was not present.
Mr. Utter wasn't.
Thank you. In the court notes, somehow it got listed as Stephen Young is non-appearing. So yes, Stephen Utter was non-appearing. We did briefly discuss the update with reunification counseling. It sounded like Mr. Utter, you had reached out to Charlotte Rosen. So essentially we took no action on November 1st because you weren't here. What can the parties tell me about status currently?
Well, I am aware of a court date that I had missed. I have since had an appointment with Charlotte Rosen on the 9th. And I've reached out via email to Keith on that status. And also
Mr. Utter, can you turn on your camera when you talk to the court, please?
I can't. It doesn't work. It's broke.
Okay. Go ahead.
I'll get it fixed for next time. I've signed ROIs, release of interest, for Keith Lawrence, for Kirby. I had an appointment with Patricia Anderson everything is good there. She is attempting to reach out to get Parker in there. It seems to be all systems go.
Okay. Let me turn it over to Ms. Young, your perspective.
I haven't heard any of this. The last update that I had was the email that he had sent Keith and I both that he was just waiting. I also have an appointment for Parker. Me on the 22nd, it's a 30-minute intake, and then November 24th, 9 to 11 for Parker. So I don't know when I haven't had anybody reach out to me regarding appointments.
Okay. All right, Mr. Lawrence, go ahead with your perspective on this.
Well, as Mr. Utter indicated, he did reach out to me to let me know that he had made an attempt to get this set up. I have not heard anything since. I did not know that Patricia Anderson is apparently the counselor, so I will be making contact to see what the status is.
And is Patricia Anderson the one doing reunification counseling then?
Correct. With California Therapist Incorporated.
Okay. Gotcha. So it sounds to me like Mr. Lawrence, before making any recommendations to this court, and this court before making any decisions on parenting changes, if any, would want to see reunification counseling started and get their input. So my gut instinct says just to set you all out so we can get those records and make sense of it all. But Mr. Lawrence, do you have any other recommendations?
No, Your Honor. I'm not sure how often Mr. Utter and Parker meet with the counselor. When we come back again, I'd like to have 2 or 3 visits under their belt so that I can get some semblance of how this is going.
Okay. Mr. Utter, how often are you meeting?
Well, that will all determine on availability and openings that they have. Right now, she gave me, like I said, till the 29th is my next appointment. She was hoping she would be able to reach out to Kirby with anticipations that she wouldn't be able to get a hold of her, is why she put it out that many weeks. And then once she gets back with me, my appointment, she'll let me know if she's talked to Parker, Kirby, and Keith, and where we go from there.
Okay. Okay.
So I have a question. I haven't had anybody reach out to me, so I don't know. I've called them, but that was just me trying to set up an appointment. So what do I need to do? Because this is the first I've heard of him making an appointment.
Yeah, Mr. Utter, can you share that contact information with Ms. Young? And then when, Mr. Utter, when you have those appointments, make sure you're letting them know that Ms. Young is trying to get a hold of them.
Yeah, that's totally fine. And I know that they've been trying to get a hold of her. Like I said, I had to give them permission to reach out to her for one reason or another.
Okay. So what could be a good review date where we would have, let's say 2 to 3 sessions with you and Parker done?
Well, the whole thing was she didn't want us to meet together until she was able to meet with him. And so that portion will rely on her, because I don't have that kind of contact even when I reach out to her or him. I haven't been able to talk to him or anything. So
okay. So we're sitting here on November 15th and you're saying you don't know when they're going to meet?
No, you're right. I don't know. I know my appointment with him is the 29th. And then her, like I said, Patricia is reaching out to her, Kirby.
Okay. Well, I think to keep this thing on track, because it sounds like there's a lot of lack of communication or missed communication occurring somewhere, let's set a 30-day review for Wednesday, December 13th. And, if we don't have visits under our belt by that time, fine, but I just don't want this to languish too long if there's some simple communication piece that could keep it moving forward. Will that work for the parties?
Yes.
Yeah.
And I also have another question of missed support payments that he's already missed for the month of October. He's supposed to be paying them weekly, and that hasn't been happening.
Okay. If you could bring that's not in front of the court today, I wouldn't have any information to rule on that. If you wanted to bring a motion for contempt due to missed support payments, we could address it at a future docket. Absolutely.
Okay, perfect.
Okay. Any,
right.
anything else on this matter? Otherwise, we'll see you back December 13th at 9.
Your Honor,
Yes, go ahead, sir.
can we get somewhere where I can get phone calls with him? All of a sudden, we took away the uncontested parenting plan that we had at one time. And then I've been reaching out to her, trying to get texting, telling him Happy Halloween.
Oh, you're muted, Mr. Utter. You're muted,
Hello?
Yep, you're muted, Mr. Utter.
Okay, I'm sorry. I would just like to talk to him again. I haven't even been able to talk to him on the phone in some time.
Yeah, so this is why we wanted you to start eons ago with this reunification counseling. So that's what all of this is for. So we can revisit that on December 13th, but I need that reunification counseling to begin. Okay?
I guess eons ago,
Okay.
like
Sir,
we had
if that's do you have any other questions for the court?
I guess not, if you're not going to allow me to talk to my son at all.
Okay. All right. We'll see you back on December 13th.
Thank you.
Zimmerman,
Thank you, Your Honor.
Christopher Zimmerman, and we have Ms. Corey with us.
Hello, Your Honor.
Hello, Mr. Zimmerman. Do we have Desiree Zimmerman? Oh, there you are.
Here.
Let me get into the file quickly. So I have us on for review. We did temporarily, at least, indicate that the children would be residing with father. Mother was in the process of changing housing situations. So maybe first I'll turn it over to Ms. Corey for any input she may have.
Good morning.
Good morning.
So I have had the opportunity to, both parents return their paperwork. I had the opportunity to review that and interview both of them via Zoom. Have not yet made visits to Mr. Zimmerman's home, and I believe Ms. Zimmerman, Ms. Fierst, is in between homes right now. I have not, as of yet, had the opportunity to meet with the children. I was able to review at least some of the court record on this case, and had a couple of questions, actually. Wondering if before the next review, and the next review is set as the final review for December 20th, is that correct?
Let's see.
Seemed a little quick.
That does seem very quick, but that is what I put in the order. But I'm also wondering why I didn't put an interim review date. And I wonder if I meant for that to be our interim. But go ahead with your question and we can rearrange dates.
If that was the interim review date, I would like to ask that both parties do a hair follicle test for the court's review before that date.
Okay.
Okay.
Is either party opposed to that?
No, Your Honor.
I agree to that.
Great.
Okay, I'm just looking. So let's do that. I can do a bench order to that effect. Let's make December 20. The interim. Sorry, I'm trying to type, look at the calendar, and write at the same time. I'm not that great at it.
I know the pain.
Okay, so interim, I'll do a bench order changing the interim GAL report to 12/20. Hopefully hair follicle by then.
And would Your Honor be looking for a written report at that time or a verbal review?
Let's just do verbal for the 20th. And then let's set a proposed final. How far out would you want to go on that? And that'll obviously put us into 2024, but as I learned this morning, it'll be the same Wednesday at 9 a.m.
So 4 or 5 weeks out would be perfect.
So what if we do that last week of January? January 31st, 2024.
Okay.
And then, will that work for all the parties? So next two court dates, 12/20/2023, excuse me, and then January 31, 2024.
Yes, Your Honor.
Okay.
Good work.
Okay. Anything else you all want to go over? Do you all, I know sometimes people get confused with where to get hair follicle testing and how to go about that. Do both of you have contact information for that? And if not, Ms. Corey does.
I was just going to go ahead and email her after the court and find that out.
Perfect. All right. Sounds good. Thank you all. You're free to log out.
Thank you.
Thank you, Commissioner.
What I have is petitioner's request for a temporary parenting plan. I do see confirmation of service on Mr. Dean, October 25th. I do see a response from you, Mr. Dean. And I did, Ms. Roning, did you see the response on the temporary plan? Oh, is she not able to unmute yet? Ms. Roning, if you're on a phone, it could be *6. I can try and send you an invitation to unmute if that helps.
Can you hear me now?
Yep, we can hear you.
Okay.
Thank you for letting me know. I was just rattling on and on, not knowing you could not talk to the court. So my apologies. Ms. Roning, what I have from you is your proposed parenting plan. I do see it was served on Mr. Dean on October 25th. He has filed a response to the proposed temporary parenting plan. Did you get his response?
Yes, Your Honor.
Okay. How are the two of you asking to proceed today? Have there been any, I guess, is there any movement on agreement? Or are you both still having small points of disagreement on the temporary plan?
I believe we're having disagreements.
Okay. Mr. Dean?
Yes, ma'am.
Are the disagreements that you've indicated in your response the same disagreements that you currently have on the parenting plan?
I believe so, though I'm just not okay with only seeing my kid 1 weekend a month deal.
Okay. What is the current, so how long have the two of you been living apart?
We still live together.
I'm in the process of getting my keys on Friday.
Okay.
To move out of the home. And I'm not, from my understanding, he's supposed to be out of the place by the end of the month as well.
Okay.
And I'm not sure where he's going or if he's staying. I'm not sure.
Okay. Well, let me ask you this, because I noticed, Ms. Roning, you indicated in your proposal that you don't believe there's any reasons for the court to limit visitation, no domestic violence, substance abuse, things like that. And so what is your reason for limiting visitation to every other week?
Well, at first I wanted to do 50-50, but then from my understanding, he had her lying to me. He was secrets that they were going to be moving without my knowledge. And that's why I pulled the parenting plan so he could not take her out of state.
Okay. So your only reason for not doing a more closer to 50-50 schedule is your concern about the child being taken out of state?
Correct.
Okay. Mr. Dean, what can you tell me?
It's just not true. She was going to move and she didn't. And so I told her I was going to move at the 1st of October, which I'd be gone on the 31st. My daughter asked if she could live with me. I said, hey, when it comes to that time, we'll see. But yes, you'll probably get to choose who you want to live with. How she took that, that's her own dilemma. I can't repeat that or whatever I need to say about it. I'm not going to take her out of the state. I've been here for 10 years with my kid. I'm here for my kid. So, and that's it.
Okay. Yeah, this is not a case where I don't have any reason to significantly limit Mr. Dean to every other weekend, especially given the current setup with you all and the fact that I'm not even being asked to look into any issues of neglect, abuse, violence, substance abuse, etc. So I would not be inclined to adopt an order that only gives Mr. Dean every other weekend just based on the evidence I have in front of me. It does not appear that the two of you, other than that issue, are that far apart. I mean, the disagreements are Mr. Dean says he wants the child's preference to be considered. Mr. Dean, at 9 years old, I'm not going to be asking the child to give input to the court on the parenting plan. That is something that we as the adults in the room are going to do together. Your next reason for disagreement is that you're not going to seek child support if Addison happens to reside with you. Again, that's not something I'm going to order from the bench. If child support applies, child support applies. If it doesn't, or if someone wants to waive it, fine. Your reason number 14 for disagreement, I think more gets to the heart of this case, which is you don't agree to not being able to speak or see your child daily. Certainly in situations like this where there's a separation or parents are no longer living under the same roof, you are not going to see your child daily. But I don't think every other weekend is appropriate either. I would like to do this because I don't feel that the two of you are that far off, and I don't sense any significant issues with substances and DV and that sort of thing. I would like to issue a bench order today, just stating that neither parent is to relocate out of state with the child. So that takes care of your concern, Ms. Roning. And I'd like to refer the two of you to mediation to work on a parenting plan. Would the two of you be open to mediation?
Yes.
I think it sounds like, just seeing how close you all are to an agreement, seems like that would be a good idea for you. So I'm going to hold off on signing the temporary order. But like I said, to address your concerns, Ms. Roning, I'm just going to state in a bench order today that pending this case, a decision in this case, that no parent is to remove the child from the state of Washington.
Okay, I do have one question.
Yeah, hold on, let me finish.
Okay.
Is there any reason that the two of you go into Portland? Do we need some sort of exclusion for shopping trips to Portland?
Yes, Your Honor. My father lives in Oregon, just in Rainier, and then Addie and I go to Portland to go shopping.
I'll say, go ahead.
I have no problem with any of that.
Okay.
I don't think state.
Okay. Visitation and trips to Oregon is allowed. Since we're so close to the border, I like to ask that question because I don't want anyone to unknowingly run afoul of this order. And then let me get you all a transfer to mediation. Currently, are your incomes similar, or is there a disparity in incomes, a great disparity?
Well, from my understanding, he has not worked. I'm the only one working right now, so I'm not sure what he's got going on.
Sir, would you be able to make a small payment towards mediation?
Yes, ma'am.
Okay. What I'm going to do in this order is just indicate mediation will be paid 50-50. It's not a large expense, and you can work directly with the mediation center on any payment plans or reductions to low or no cost mediation. Okay. And then I know there's a move-in process. Would an address or phone number for either one of you have changed since you filed documents?
Yes, mine.
Okay.
I'm muted again.
And Longview still?
Yes, ma'am.
Okay. Has your phone number changed?
No, Your Honor.
Okay. So I'm going to get this filled out and signed today. Mr. Dean, has your information changed, address or phone number?
No, ma'am.
Okay. Community mediation will be reaching out to you. What I'm going to recommend is that following whatever date they give you, if you have an agreement, great, get it back onto my docket and we'll sign the agreed parenting plan. If there is still disagreement after mediation, that's fine too. You probably will find there's some points of agreement and maybe 1 or 2 points of disagreement. Go ahead and either one of you renote those points of disagreement back to this court. I'll make the final ruling on those and we'll get you your temporary parenting plan.
Okay, I do have a question, Your Honor.
Okay.
So with me moving, so do we just, I'm taking Addison with me to move, and I'm not denying her visitation with her father, but how does that play out?
Well, I could put in a temporary bench order that, now, how close do you guys live together? The old place and the new place?
We're only 8 blocks apart.
Oh, only 8 blocks?
Yes. Yeah.
So what I would like to see then is as close to 50-50. So same school district, she's able to get the same bus?
Yes.
Okay. So what I would like to see is a split of time right now until you go to mediation and we have a temporary parenting plan in place. So does it work best for you to do 1 week on, 1 week off, or do you guys want to split up the same week?
Well, I was gonna ask if he could do like Monday, Tuesday, Wednesday, and I could do Thursday, Friday, Saturday, Sunday. And then if I'm working, then he can watch her while I'm working. If that works for him.
Mr. Dean.
I think we can come to the agreement where, because she usually works at nights, if I see her in the evenings, and if need be, she can pick her up after work.
That'd be great.
Okay. So it sounds like until you go to mediation, it sounds like you guys can come to an agreement on this. Do you want something specific in a bench order?
No, I think we can figure this out.
Yeah. No, kudos to both of you. I think you're both approaching this from the best interest of your child. Mediation should be able to get you in fairly quickly. If, as you do this move, if you guys find that you're not able to come up with a temporary plan that works, just renote it back on if for some reason mediation's way out there. But, you know, my guidance is I don't see any red flags in any of the filings from either one of you. So if you were asking the court for an order today, it would be as close to 50-50 as we could do. So that would be my marching orders for what you guys do temporarily. Okay.
Sounds great.
Okay. Thank you both.
Thank you.
Let me just get back into the digital part of that file.
Both parties are, both counties are hopping today, I think.
Yeah. Everyone's trying to get things done before the short week next week.
I think it's true.
Okay. So we had a lengthy hearing back on October 18th. We appointed you at that point, so I know it hasn't been a ton of time.
Yeah.
So I think we're just here kind of, my understanding is an initial review, seeing if there's been contact, if paperwork's been filled out.
Yeah, so I have been able to have contact with Ms. Gibson. She completed her intake packet and paperwork, sent it back to me. I have not yet heard from Mr. Bissig. I hope I'm pronouncing that correctly, by the way. Is it Bissig?
Yes.
Okay. I texted him. To be fair, I texted him last night, to be fair to Mr. Bissig, but he did receive my packet a little more than 2 weeks ago. Has it been 2 weeks yet? Almost 2 weeks ago. So I haven't had any contact or input from Mr. Bissig yet. I have read through the majority of the case file and kind of seen what's going on. It seems to me, if Your Honor is amenable to this, that a substance abuse evaluation would be appropriate for Mr. Bissig at this time. I would be very curious also about a mental health, but I understand that there's financial restriction. I want to be careful about trying to make too many things happen at once. But a hair follicle test and a substance abuse eval, I think, would be very appropriate for Mr. Bissig going forward. But again, I'm saying this without having read his intake paperwork yet or having had a conversation. So I want to be aware of that.
Okay. Ms. Gibson, is a hair follicle test and substance abuse evaluation something that you would be requesting of Mr. Bissig?
Yes, as some things have been brought to my attention recently, I would appreciate for a hair follicle test and a new evaluation at a different clinic than he is currently going to for treatment.
What?
So, Ms. Gibson, help me understand your request for that if he's already in treatment.
So he's been in treatment for a few years now due to a DUI.
Mm-hmm.
The whole time he's been in treatment that we were together, he never quit drinking like he said he had. The first visitation that he had with the kids, somebody had called me concerned about my children because they were at the same place that he was with the children and said that he seemed very intoxicated.
I don't have that in a sworn declaration or anything, so it's not something I'm going to consider today. Ms. Gibson, if you certainly want to get some sort of statement like that under penalty of perjury, the court could consider it. Okay. Mr. Bissig, so I'm going to ask you just a couple questions. First, are you able here pretty quickly to get that packet of info back to the GAL?
Yes, I just haven't checked my email, so I didn't know it was in there until last night when she texted me.
Okay. So we'll give you some additional time to get that done, no problem. And then would you be in agreement to presenting yourself for a hair follicle test? Those results would go to the GAL.
I don't think it's necessary since I'm already in treatment and in mental health, and they already gave me UAs.
I want to be clear to Your Honor, I did not understand that Mr. Bissig was currently in treatment. Like I said, I'm sort of missing some pieces of this puzzle.
Yeah.
So if that's the case and and I can contact those folks and receive that information from his current treatment facility, I'm very open to that.
Yeah. So let's do this. Let's do a little bit of a shorter set over. I will take under advisement the hair follicle and sub-eval testing, but I think that does make a lot of sense, Mr. Bissig. If you respond in that packet with the names and contacts for your current mental health and substance abuse treatment, the GAL can review that information, and it may negate the need to do anything more. To be fair, sometimes it raises more questions. We just don't know. But I don't think there's enough here for any of us to say for sure that you need to go do these things. So let's have you get that contact information to the GAL, and then we can go from there, okay?
Okay.
Okay. How long do you think you'll need, sir, to fill out that packet and get back in touch?
I can start filling it out today.
Okay. If we did, I know it's going to take I said short set over, and then I realized, yes, but we have to request information from treatment providers. So we probably are looking at 30 days, to be honest, at a minimum. So I'm looking at December 13 for a return date. How will that work?
I was under the impression we already had a 60-day review date on December 13th at 9 a.m.
We do, actually.
Then that works even better. You all are already available. Thank you for pointing that out, ma'am. So
Your Honor, on that date on the 13th, would you like a written report, an interim written report, or just a verbal review? Would that be appropriate?
A verbal review would be great.
Okay. Sorry, I lost my train of thought for a second. Go ahead, Your Honor. I apologize.
Well, I was just going to ask if there's anything else that the parties need to talk to the court about today. Otherwise, we'll see you back on the 13th, and just encourage Mr. Bissig to get that paperwork back ASAP.
Your Honor, I do have
Yes.
one thing.
Okay.
When we last saw you back in October, I had requested, when we were setting up all the limitations and all that for the visitation, that I do receive a itinerary from Mr. Bissig for where he's going to be and what he's going to be doing with the children, so that I do know where the children are going to be at for their safety. That has been a problem. I had requested and messaged to Zach and Dodie, the supervised visitation, his grandma who does the supervised visitation with him, that I get itinerary a minimum of 12 hours in advance so that I'm aware of where my children are going to be. That hasn't been happening. Communication with him has been very difficult, as when we are doing drop off and pick up, I'm trying to give him necessary information on the children, and he just walks away from me. And so I'm just asking for an itinerary in advance, not when we're getting there for drop off.
So help me understand why you're asking for that. I'm looking at the order, and it says parents to communicate regarding locations and timing of supervised visits using Our Family Wizard. That's what I wrote into the order.
And
why are you needing itineraries 12 hours ahead of time?
So that I know where my children are going to be, because
how is that any different than getting the itinerary within an hour of him picking up the kids, or as he's doing it?
I have to ask for it every time.
Okay.
When we're doing it. I'm asking that he make the communication towards me, because he's not making the effort to communicate with me about the children.
Okay. Well, I'm denying that request. I think that's an overstep into his parenting time. He does not need to provide an itinerary 12 hours ahead of time to you. This is a situation where everyone is going to have to learn to give a little with regard to your control. I understand that need when it's your kids, but what is in the parenting plan that he does need to comply with is, at the time of the visits, he does need to tell you where those visits are taking place. He does. Mr. Bissig, you need to use Our Family Wizard, to communicate to Ms. Gibson where your visitation is occurring.
Yes, Your Honor, I can do that, but she don't message me on there. She only asks me when I pick up the kids. So I tell her everything time.
Perfect.
elder, and she has not contacted my grandma at all.
And that's fine. And I see that Doris Johnson still is the supervisor who must be there at all times. So with that safety guard still in place, I'm not going to require 12-hour notification of where you're going to be. But sir, it is incumbent upon you to use that app and send your itinerary is a strong word. Please let Ms. Gibson know where you are with the children when you are with the children.
I can do that.
Okay.
Your Honor, can I make a
Okay.
request regarding our family wizard? I'd like to be able to have access to that communication
Okay.
so that I can monitor, if that's helpful.
I think that would be helpful. I call it magic, so I don't know how that actually would happen, but I assume you know how to make that happen.
I do, yes.
Okay.
I just like to sometimes have that included in the minutes so that we can make sure that that's taken care of.
Perfect. I will make that oral ruling that the GAL is to have access to the Our Family Wizard communications. Is there any objection, Ms. Gibson or Mr. Bissick, from that?
No, Your
I
Honor.
can agree with that.
Okay. Okay, great. Well, we'll see y'all back on December 13th. Good luck to you all.
Thank you, Your Honor.
All right, thank you. All right. So my understanding in review of this is that petitioner Ashley Bryant initially proposed a parenting plan on or about August 29, 2023. I have reviewed that parenting plan along with the supporting documents. And then on October 24, 2023, Mr. Bryant proposed a parenting plan with supporting documents that I have reviewed and received. They subsequent to that, those are just the notices of disqualification. So anything else beyond the initial filings, which does include also any sealed documents, the financial declarations, the proposed child support worksheets, et cetera, anything else the parties believe I should have?
And Your Honor, sorry, before Mr. Vandy makes argument, I would like to address a preliminary objection. Just within
let me answer that question first. The reply declaration that my client filed back on October 31st, Judge, with attachments, there's a sampling of a couple of text messages and various pictures of Mr. Bryant in state of what appears to be intoxication throughout the property and signs of alcohol abuse. And again, that was filed back on October 31st.
I do have that, and it's 11-page declaration with attachments of pictures with cans, essentially with dates on those, someone laying down in one of the pictures. And then the text messages at the top, it says, quote, past unstable communication.
Correct.
Okay.
Yes, and that was the basis of my objection. Pursuant to Local Court Rule 88, the declaration is limited to 4 pages, and the declaration itself contains a litany of new allegations. My client didn't have the opportunity to respond to the text messages. The pictures are, frankly, I can't even see what they're trying to be portrayed. So we are asking the court not to consider the new information contained and then anything after the 4th page within the reply.
Well, and Judge, I think if you count the pages, there's exactly 4 pages. It goes on to page 5, but you get credit for the first half of page 1, which is the caption, as required by the clerk's office. And as it pertains to the information of the pictures, that's directly in response, and that's the purpose of the reply. That's directly in response to Mr. Bryant saying he doesn't have alcohol problems, and it came back from which I'll address an argument. His evaluation from Safe Haven that says he doesn't have any problems. And I think the pictures directly contradict everything contained in his declaration. So it's not a valid objection just because it's damning to your case and you want to admit it. That specifically complies with the rule as it's in direct response to what he had claimed in his declaration.
Your Honor, may I respond?
Go ahead.
Washington State's a notice pleading state. Mother has had a wide opportunity to provide her materials in support of her allegations. She had these messages. They're frankly old based on her handwritten notes for them. They should have been contained within her underlying motion. My client should have had the opportunity to respond. And because of that, the court shouldn't consider it today.
So a couple things. I am going to allow the declaration in its entirety. It might be a couple lines over 4 pages. But I do believe it is relevant to those things that were raised by respondent once a response was filed and the parenting plan was filed. For the same reason, I am going to allow court's consideration of those documents. Again, I don't believe all of this information is something that should or could have been pled initially, I think there's a question of obviously waiting to see what respondent is going to agree to or not agree to before the petitioner would then need to come forward with this information. And I think it makes sense that sometimes petitioners don't want to air all the dirty laundry initially. I will say my only concern is I can't make out, well, two concerns. I can't make out the text messages. The pictures are real clear to me. The text messages, I think even if I take my old lady glasses off, I don't think I can see them.
That's fine, Judge. If you can, great. If you can't, that's fine too. I anticipate a GAL will have access to those. We blew it up as big as we could, and I struggled this morning and last night too in trying to decipher those. I think it largely kind of complies with what my client states in the declaration. It gives that credence to those positions just based on the interactions between the two of them. But again, the GAL will be able to see all of those.
Okay. And then my only other, Ms. Gilmore, I certainly understand your position about response. Do you want any additional time to respond to the October 31st filing?
I guess I would need to speak with my client. I don't want to cause any really further delay. I know that this has been delayed. I know he does have responses, and I do think he has the ability to provide a response to them. Travis, can you just indicate if you would like to respond to the additional material?
I can put you two in a breakout room too. If you want to proceed today, great. If not, I could put you on to next Wednesday's docket. So totally up to you.
Yes, if you could.
This Gilmore wants to have latitude and go beyond what was contained in her declaration. In response to that, I'm fine. Again, I don't think it in the context of the argument. So I'd be agreeable to that if she wants to make some oral argument today that I guess whatever Mr. Bright has to say in response to that, I'd be fine with that.
Ms. Gilmore, do you want to break out room quickly?
Yes, please. Thank you. Thank you, Your Honor, for that. My client would like the opportunity to respond. However, I don't want to necessarily cause a delay. Mr. Zandy and I have been speaking about potentially having the court review the materials and making a ruling off docket. My thought is that I could present a pretty brief reply within the next day or two. And then once the court has those materials, you can make a written ruling, or I'll defer to the court and we can set it over a week.
Mr. Zandy, your position?
Yeah, I certainly don't want to set this over. This is a case where these parties have been living, I'd say awkward, but the word doesn't seem strong enough, circumstances since June. This is a case that needs some kind of resolution on a very near basis. I am fine, and Ms. Gilmore is correct in that. If you, and I trust Your Honor has had the opportunity to look through that thoroughly, certainly seem more beyond prepared today to address these issues. If you're comfortable making a reviewing the pleadings, making a written ruling, I'm okay with that. If you prefer to have argument like we would traditionally do, I would just ask we go forward on that today. Essentially, whatever you prefer. I just don't want to come back next week as it's already almost 11 o'clock. We've prepared this. We've been here. The objection was overruled. I think we're ready to move forward today. But again, I'll certainly leave that in your capable discretion.
So let's do this. I have the child support contempt docket that only has 4 matters. It's going to take about 5 minutes. I am going to jump onto that right now and get that cleared out. Come back to you all, allow for brief, you don't have to log off. I'm going to keep this Zoom going. Allow you all to do brief oral argument, and then we can recess and I'll give you a written parenting plan decision. Will that work?
Fair enough. Sure.
Okay. I'm going to have to hand off in support of your position, and then Ms. Gilmore, go ahead.
All right. Thank you, Your Honor. And as the court is aware, I do represent the petitioner, not the moving party to the motion in front of you today, named Ashley Bryant. We're here on my client's motion for several forms of relief pertaining to the temporary orders and kind of how do we set this in motion, where do we go from here? You're well versed in this case. This is a 13-year marriage in which there is a 12-year-old child born as issued, namely Riker. Riker has a step sibling who's 18-year-old senior in high school, Ellie. Ellie is obviously not part of the jurisdiction for the court today. I can't include her on any parenting plans or visitation schedules, but nonetheless, she's attending school and is certainly the stepchild of Mr. Bryant and the biological child of my client. Ellie's a senior in high school. As we move forward, again, I think it's pretty obvious what the concerns are. This is all seems to be centered on an extreme level of alcohol consumption of Mr. Bryant. This has been an issue that's been prominent throughout these parties' relationship. It's gotten progressively worse. I think if you look at my client's statements in her declaration, as well as some of the supporting material, you'll see that this is largely an unresolved issue. And my client's primary concern is the impact not only on her well-being, her safety, but most importantly that of Riker. Riker, we have a 12-year-old child who absolutely loves his dad, and there's no doubt about that. He's also at an age where he's starting to model his parents and his father. And unfortunately, this is a case where Mr. Bryant has exposed the child, or at least been privy to information related to DUIs and seeing his dad intoxicated to the point of passing out. And we're not talking about a bad night here or there. We're talking about consistently over the past several years. That's the basis for this. We were quite surprised to get Mr. Bryant's responsive pleadings in which he says, I don't have any alcohol problems. Look, I've got a unilateral one-sided report from Safe Haven where I gave them essentially the information I wanted them to know, and I'm fine. And that is just not borne out in front of the information from them. If you look at that report from Safe Haven, and this is just within quick review upon receipt a couple weeks ago, several things stand out. Number one is the fact that Safe Haven is less than concrete in their diagnosis of him. If you look at the report that was submitted by Mr. Bryant, it says history of substance abuse disorder. It said a DUI in 2016. My client details for you, there's been, to her recollection, 3. Mr. Bryant, in his own responsive pleadings, cites 2 prior DUI instances. For some reason, again, the Safe Haven report only reports the one from 2016. If you look further down, you'll see that the client reports, this is in the middle of the page, the client reports staying abstinent over a year after completing his treatment program. That's in reference to the 2016 report. Again, in review of that, my client has given you information and pictures which directly refute that. And so again, to suggest that I don't drink or consume alcohol anymore, I've been clean and sober, is simply disingenuous, or probably more applicable. That's just not true. Again, that's borne out by the information we provided. If you look at this, it's extremely disheartening for him to essentially come before this court under the penalty of perjury, say I don't have alcohol problems. It's being manufactured by my spouse and divorce litigation, when the information just doesn't reflect that. We also have, and again, I think these probably go hand in hand. And my client details for you. She says when Mr. Bryant drinks, he becomes cruel. Now there's these issues after he drinks, and that's unfortunately very common, in which he acts out, lashes out at her physically, emotionally, and the like. And the kids, again, most notably Riker, are privy to that and exposed to that. And that's unfortunate. As early as June of this year, we have this. And my client gives you the pictures because, again, this has become so commonplace for him. She takes pictures of him passed out in various places. There's pictures of him which appears to be on the floor of a shop. There's one from December 23rd where he's just kind of laying passed out again in another form or another area of the home or on the property. And we have this issue from June 18th in which he shows up, assaults the person she's visiting, assaults her, is charged with various offenses. And my client has the picture showing you the amount of ocurrs that he ingested that day prior to, again, showing up this person's house. In light of all these things, it strikes me as incredibly dishonest for him then to file under the penalty of perjury these documents and say, I don't have any issues. The text messages and communications my client details for you in her reply declaration just don't point to somebody who has that. This is a cycle. This is one where he passes out throughout the property, awakes the next day, goes to work, prior to going to work, disposes of all the quote unquote evidence of the empty beer cans, and then apologizes and said it's not going to happen again, only for, again, the circle of the cycle to continue to manifest itself. And we have the issues of not only that happen again, but getting more frequent in intensity and duration. So from a stepping off point, that's the big one. There was, through, as the court is aware again, because it was filed in Calhoun County, an initial no contact order back in June. Because of this, these charges, and because of what occurred back in at that time, he had the charge of domestic violence in the 4th degree, assault in the 4th degree, burglary. And what does he do after that? He drives there, but he flees on foot. My client details for you because during this interaction, he was extremely intoxicated. He waits several hours before he initiates contact, knowing that the police are looking for him. And again, one can only logically assume that's to avoid exposure on the DUI. So if you look at this from, again, you don't have to be overly intelligent to see what's going on here. It's very concerning. My client details for you, and I would certainly argue that we struggled in putting a proposed parenting plan together. And again, we're at odds a little bit with a 12-year-old who loves his dad. We're at odds with then the issues that Mr. Bryant has routinely exposed his child to pertaining to this alcohol consumption and the cruelty that follows after that. So what do we do with it? We proposed, again, something that we think is manageable, and we're balancing the fact that these problems offset from the relationship that we hope that this child has with dad. My client details for you that Riker has been kind of ambivalent towards this over the past couple of years. Again, this is now getting to a point which is very unfortunate, but this is normal for Riker, and it shouldn't be normal for any 12-year-old. What we're proposing is a parenting plan which gives Mr. Bryant the time with his child, not too much time. Again, the suggestion made by him that this should be a joint parenting plan because he's been involved, I'll comment on that in a moment, is we can't have a joint parenting plan for these folks. Again, Mr. Bryant is capable of having a joint parenting plan, and based on the history, that would be a recipe for disaster. We're proposing that he have every other weekend, Friday to Sunday. We're also asking that he have some midweek visitation for a couple of hours. The one request my client has is an absolute prohibition of him drinking during any time with Riker or immediately prior to any visitation, which we would identify as within 8 or 10 or 12 hours, whatever the court deems appropriate for that. That seems like it should absolutely kind of be a stepping off point for this. Also ask that my client have the ability to give him a UA as needed to make sure that he's following that provision. We're also asking that Riker have an ability to contact his mom. Again, he's 12. He knows dad's kind of tips when it comes to this. That he can contact my client if dad is violating that, if dad is impaired, if dad is acting in ways that show that he's probably or likely under the effects of alcohol. It makes sense given the circumstances and the age and maturity level of this child to be able to call a mom and say, please come and get me. And we think that is certainly reasonable. Moving forward, again, I think this is also a case where if the court grants our proposed parenting plan, which we certainly believe strongly is in the best interest of this child, that we make some kind of ruling on the real property in the home in Castle Rock. As I stated previously, there is a request by my client to maintain and be awarded that home on a temporary basis. Again, Mr. Bryant focuses on the long term, says, well, she didn't even want this house, and here's an old text message to show that. We can't even get to that point at this juncture. Far too soon for that. We haven't exchanged discovery. We don't know really what's going to happen to him on the evaluations that we anticipate are going to be ordered on the alcohol and potentially domestic violence side. We don't have any GAL input yet, and deciding long term what happens to the house is completely premature. What we do know is we've got 2 kids, one who's 18 and in their senior year of high school, one who's 12. Again, the subject matter of this court for parenting plan. We're in the middle of a semester going to Castle Rock, doing relatively well. The last thing they should do is be uprooted from their home. It stands out to me the suggestion, Mr. Bryant. He says, well, I want a joint parenting plan, even and denies this issues. Doesn't have a plan for dealing with those issues, just says they don't exist. He wants the home, he wants a joint parenting plan, he doesn't want to pay child support, and he essentially wants my client to relocate and start from scratch, earning less than half of what he earns, by the way, in another home in the middle of a semester for 2 kids who are otherwise doing well. We don't think that's appropriate. We also have the concerns that my client voices for you as to not only him passing out after work and consuming large quantities, which appears to be the Coors products, but we don't just have that. We also have some of these other issues where doors are getting hit, where my client wakes up at 1 a.m, he's standing over her. We had the no contact order that was put in effect by Commissioner Warning as early as June with these criminal charges that were still pending. These parties cannot live together. Again, so setting a drop dead date for Mr. Bryant to get out of the home and relocate seems very appropriate. And we ultimately need to take the kids out of this chaos and this awkward situation. And again, at 18 and 12, they recognize that, they can certainly feel that. And there is a rich history of the impact of Mr. Bryant having those lapses where he's basically passes out throughout the property. Again, we were surprised to read his declaration in which he details the amount of involvement he's had with not just Riker, but Ellie as well. My client details you that is not true. And my client details for you, and again, it seems rather basic, but there's no explanation from him. He works at least 2 overnights per week, and the other time he hangs out by himself, consuming alcohol and essentially passing out. So again, I guess the allegation or the statement by him that he puts the kids to sleep every night, that just isn't borne out by the information in front of you. It makes very little practical sense. My client is asking for the home, also asking on a temporary basis, also asking for the financial relief as we've cited. We did provide for the court's review proposed set of child support worksheets. We're asking the court to adopt those figures. We're also asking the court to make some kind of an allowance for family support or all in the alternative spousal maintenance. Again, if you look at the incomes, and it doesn't seem disputed, this is, I think, the one thing these parties can agree on. It's the fact that Mr. Bryant makes significantly more than my client. He's at about $110,000 per year. He works a good job at West Rock. Now, my client also has a good job as a collections agent at Fiber Credit Union, but her job does not earn near the amount of income as that of her husband's. Now, my client's on pace to make about $52,000. And again, after a 13-year marriage, given the financial situation and need of my client, coupled with RCW 260990. We believe the factors are met, and we think an award of family support, or again, alternatively, spousal maintenance is appropriate given the disparate financial situations of the parties. From that, my client is willing to pay the mortgage on the home. There's actually two, provided she's in the home as we proposed. That's about $1,800 per month. Again, having her pay that, having Mr. Bryant pay some towards alimony, goes toward the mortgage, and it preserves an otherwise community asset. And we think that certainly should be the goal of these folks and put them in a position where they can do that. My client also has a Chevy Tahoe payment of $235 a month. She obviously has the utilities. She obviously has the groceries for two near teenage children. And as the court is aware, groceries are not cheap in this day and age. She also has the other need of her credit cards, which again are largely in her name. He has those in his name. We propose that if the court does adopt our form of relief, that he's got a girlfriend. I don't know what the status of that relationship is, and I'm certainly not suggesting he move in with her. That's certainly his choice that they can make together. But there is of note a 2017 Keystone trailer, which is very nice. It's newer. It's one of the better trailers, and it's more than comfortable. My client states that he can take that basically and reside in that, hopefully getting some kind of treatment in the meantime, except the fact that he has some alcohol issues and deal with those. And again, having possession of that trailer at only $373 per month gives him a potential landing spot where he can rent a space or alternatively live somewhere else if he's so inclined. That's reasonable, and I think that makes the most amount of sense given where we're at. And that's what we're asking the court to do. My client is asking for $1,500 specifically in the alimony side or the spousal support side, in addition to the child support. I would certainly stipulate that whatever you award in spousal support, provided the court is inclined to do that, should be applied and treated as such on the child support worksheets, which will impact that transfer one way or the other. I would certainly stipulate that that's appropriate. And finally, that we do get some award of attorney's fees and costs. I didn't see a response from Mr. Bryant in his pleadings. We requested $2,000 in temporary fees and costs. That is certainly not the full award of what my client paid me for a retainer, but it at least will help her get through the discovery portion of this case, get through temporary orders, and we can kind of proceed from there and hopefully put these parties on a track to a resolution through settlement. They both need that. These kids need that. They need to get on with life. I think in the meantime, appointment of a GAL is likely appropriate as well, given the substance abuse issues and given the criminal history, which is very recent. Mr. Bryant, given both parties' allegations against each other of the new boyfriend and new girlfriend, I didn't see that was problematic either way. But nonetheless, there are several issues. Oh, and the domestic violence. There are significant issues for a GAL to investigate. And if the court wants to set a review a month or two out and give that person time to report back, my client's agreeable to that as well. Just asking that the percentage of the GAL be apportioned according to the percentage of income off line 6 of our proposed worksheets, which again seems part and parcel for typical tradition of what we normally see. And we certainly would not be opposed to that.
Okay, let me just start. Thank you, Mr. Zandy. Ms. Gilmore, let me just start with what might be the low-hanging fruit. Is your client opposed to appointment of a GAL?
We're not, Your Honor. We would like to get that entered today, potentially, or just have to get a name.
Let's get a name for that. Give us just a minute.
Okay. So the next three names are Heather Kale,
Amy
Turnbull,
and
Ann Height.
Ann Height.
I'll strike Ms. Turnbull.
I'll strike Ms. Kale.
And that leaves us with Ms. Height. Is that correct? Okay. And one of you can prepare that order, I assume, with Ms. Height. And then let's talk about payment just briefly. It looks like using both of your numbers, he makes about double what she makes. Go ahead.
Worksheets. Based on my worksheets, he would be paying 60% of costs and she would be paying 40%.
Mr. Zandy, do you have any objection to that?
I think we're splitting hairs at 60-40. I'm fine with that.
Yeah. Okay.
I don't think that percentage is accurate, but I don't think it's also worth arguing.
Yeah, I understand. I think that makes sense in this case. So if one of you wants to prepare an order, 40-60, petitioner 40, respondent 60%, and Height, feel free to put in the dates. I think, well, you'll be stuck on this docket. So it's always going to be Wednesdays at 9 a.m. through 2024.
Great.
Okay. So then Ms. Gilmore, go ahead on your objections to the proposed parenting plan and your support of the parenting plan that you've proposed.
Yes, Your Honor, and for the record, Megan Gilmore on behalf of the respondent and non-moving party, namely Travis Bryant. My client's declaration is thorough and the records speak for themselves, so I will keep my argument relatively brief, and I'm happy to answer any questions that the court has. As detailed and linked up in my client's declaration, he has been the primary parent of these children during the marriage and after separation. My client's work schedule allows him to be available for the children as referenced within the communications directly to and from the children themselves. My client's work schedule is 4 on, 4 off on a rotating basis, with 2 of those being night shifts. So it's rotating. It's not as depicted within petitioner's materials, and even more flexible than that presented. My client is the parent that attends teacher conferences and doctor's appointments. Even prior to separation, my client was the parent that was doing homework, making dinner, tucking the child into bed at night, as mother didn't return home from work until the late hours because she just simply didn't come home. Following separation, my client remained the stable parent of these children, which was demonstrated within our calendars, and my client has 12 months of those calendars that we're happy to present to the guardian ad litem throughout the investigation. Interestingly, petitioner doesn't dispute my client knowledge of the schedule within her reply. These records show that mother isn't home until between 8 and 11 p.m. on the weekdays, and she's not returning at all on the weekdays, the weekends. Mother doesn't communicate with my client or the children, and she's gone for between 3 and 5 days simultaneously on a weekly basis as set forth within those calendars. And we simply just don't have any response whatsoever from her regarding those. Mother has been so absent since separation that my client explains in his declaration that she wasn't even present for her own daughter's homecoming dance. My client, as the primary parent, watched her get ready, take pictures, and supported the child that's frankly not even his biological child. But for my client's role in stepping in as continued primary parent of these kids, based on the schedule, these children would have been left alone for extended periods of time. The children's desire to live with my client ultimately frustrates petitioner, and she's involved them in conflict following filing this litigation. It rose to a head at the point where the mother yelled in front of the children that she doesn't care if the kids are even around her. My client was again frankly surprised that petitioner requested the home on a temporary basis, as she very clearly doesn't want to reside in the home permanently and has been residing with her boyfriend a majority of the time since separation. Outside of the self-serving statements, my client petitioner presents nothing to support her role as primary parent. Contrary to that, my client is providing not only his testimony, but doctor's records, text messages, calendars, pictures, confirming not only his role as primary parent, but the current status quo. Petitioner attempts to claim that my client is only recently manufacturing this status quo. However, I asked the court to look to the medical records submitted under seal, and that was submitted to the court on October 24th. Petitioner tries to delegitimize these records by claiming that they're somehow all within a short period of time, again, manufacturing the role. However, they may have been printed on September 18th. However, the records are from a lengthy period of time. If you look to the end of those records, in fact, it shows a well child checkup from when the child was 10 years old, which the child is now 12 years old. All of those records show that my client is the only parent attending those appointments. Petitioner doesn't deny that my client was the parent to attend teachers' conferences, and even during active litigation, she didn't attend a teachers' conference this year. To the contrary, petitioner knows the historical roles, and she uses the residential schedule as a vehicle to obtain more support and is willing to fabricate allegations against my client to legitimize her claims. My client has never been domestically violent. It is undisputed by the parties that they've continued to reside together for almost a year since separation. If my client was in any way domestically violent or a risk to petitioner or the children, petitioner would have sought a restraining order in this action. The criminal case involving petitioner was dropped because no assault occurred, and there's no criminal actions pending. Petitioner doesn't seek limiting factors within her parenting plan for domestic violence and is agreeing to joint decision making. Again, there's simply no DV in this case on the part of my client. To the contrary, we submit within our declaration an instance where petitioner was actually assaulting my client, not only assaulting my client physically, but then threatening and stalking my client's friend as detailed within her declaration. Similarly, petitioner has nothing to support her claims that my client has a substance abuse issue, which my client adamantly denies. Petitioner fails to acknowledge within her underlying motion that my client's his most recent DUI was from 7 years ago in 2016. He was forthright with the court and provided a watch report that he did have a DUI prior to that. That was from 2016, 17 years ago, 5 years before the birth of this child. The only evidence that she presents in support of her substance abuse allegation is undated pictures of cans with no location or association with my client. I mean, she frankly could have gone to the side of the road and taken a picture and now submits that this is somehow associated with my client. Similarly, she takes pictures of my client allegedly my client, frankly, I can't even identify, laying in a chair, but there's no, looking to the underlying background, there's no sort of cans or alcohol related whatsoever to these pictures. My client presents to the court a substance abuse evaluation, and I think that that is also misconstrued within the reply materials. My client acknowledges within the evaluation that he did have a DUI in 2016. He acknowledges that he engaged in a substance abuse evaluation and treatment at the time, and he also acknowledges that he did not drink for 12 months subsequent to that DUI arrest. But there is no, they're not catching my client in any sort of lie, because he's testifying to the court that he didn't drink from 2016 to 2017. They submit pictures and text messages from as early as 2021, but there's no collaboration between my client's statements to the substance abuse and their allegations in the reply materials. My client has worked at the same location for 19 years and is well respected, as provided in the testimony of his employee. Petitioner makes baseless claims against my client about being blacked out in front of the child, but also doesn't deny leaving the children in my client's sole care for a vast majority of the time. Petitioner's statements and actions simply just don't align in this case. My client does not have a substance abuse issue and is not domestically violent and does not treat petitioner or the children poorly ever. My client is the children's primary parent for their entire lives. This is evidenced by the picture evidence, again, the text messages, communications between the children, the calendars, and the like. We are asking the court to adopt our parenting plan as we believe it's in the best interest of the children. We're not asking for a joint plan. We're not asking for the children to leave the residence. We're asking that the children continue to reside in my client's primary care as they have been since separation, and certainly for the last 3 to 6 months as presented within the materials. I, again, frankly, hope to finalize this case sooner than later. I don't think that there's huge issues once the parenting plan is resolved. And so my concern is that if we force my client to move out, and we have basically an agreement that petitioner doesn't want to reside in the home, can't reside in the home, it doesn't make sense to force my client to move out, and then the parties hopefully reach an agreement in the next 90 days. My client then has to move back in. It just simply doesn't make sense in this case. And petitioner also doesn't acknowledge within her reply materials that this is a home with substantial land and animals, frankly, a farm, that my client has been solely responsible about caring for. She doesn't explain to the court how she's going to be able to maintain the land on an interim basis. And we are concerned about the condition. So we do ask the court adopt our parenting plan as it's in the best interest of the kids. We ask the court allow my client to stay in the home. My client's obviously more than willing to pay the household expenses if he's allowed to do so. As to financials, as of August 6, 2023, my client's gross annual income was $78,547. I divided that by 7.69 months. That gives my client a gross of $10,214 or a net of $7,279. Looking to petitioner's income, we have pay stubs as of July 31st. That shows a petitioner's gross annual income of $40,836. I divided that by 7 months. That gave her a gross of $5,833 or a net of $4,748. Petitioner requests within her materials for the court to basically impute her at her current rate of 40 hours. However, that's not appropriate and not borne out by the pay stubs. As the court is aware, when ordering support, the court needs to look at need versus ability to pay. Petitioner makes a good living, and even if the court looks to the face of her financial declaration, which has her covering all of her household costs, there's simply not a need in this case. My client has continued to financially care for not only the child of this action, but the child that petitioner brought into this relationship financially, emotionally, and the like. Petitioner fails to acknowledge within her financial declaration that she's receiving child support for that 18-year-old. And again, my client has been paying and supporting this child since separation and beyond. If the court names my client primary parent, we are asking that court enter no child support, no spousal support be exchanged between the parties. It just simply doesn't make sense. And lastly, we are asking the court to deny fees. Given the lack of need, and my client has been financially supporting the household as well as the children, my client did note this objection within his response to the petition. Thank you.
Is there some, just one question on maintaining the land? Is there some reason that your client believes the wife can't maintain land?
She just hasn't ever done it, frankly, and they have, I think, farm animals that she hasn't participated in either. So that is the basis. It's just the historical roles of maintaining it.
Okay.
And I don't necessarily think it's farm animals, like a farm is being painted. I think there might be a couple of goats and maybe some chickens. I don't think we're talking about cows, horses. I don't think we have any of that stuff. I mean, it's animals.
What's the size of the land? Like acreage?
Well, it's on Sandy Bend Road, and I've got a C of A.
Travis, can you speak to that? Probably easier.
It's 7 acres.
Okay. Okay. And then it looks to me, and I will just by Friday get you a written printout or a written signed document for the parenting plan. On the child support worksheet, Mr. Zandy, it looks like the respondents' numbers are both a little bit higher than yours for gross income. In taking a look at their proposed worksheet, October 24, 2023, do you have points of disagreement with that? It looks like they have, even though the names look like they got transferred, it should be Travis in the first column and Ashley in the second. They have Travis at 10,214 and then your client at 5,833 based on actual pay stubs.
So keep in mind, we didn't have his pay stub because we were the ones that filed. So oftentimes you don't have the most up-to-date information. Yeah. This is why I treated apples to apples and just used off the tax return for 2022.
Got it.
Realizing that either party had been subject to a gross increase, or at least that we're aware of. I can run new worksheets, which again, with the most recent information, I don't know that it's going to make a huge change. And then you'll notice on my proposed worksheets, I did give him the benefit of the maintenance paid and gave my client the calculation for the maintenance received, which again puts him still at about $500 to the plus side of where she would be, but that's factored into my proposed worksheets. And yes, if you look at theirs, they have the parties, it looks like their worksheets are wrong. I'll just say that. They've got the parties as identified in incorrect terms.
Beyond it being in reverse, I do think that our income analysis for her is accurate based on her current pay stubs. I think that was the question.
Okay. Okay.
You want to rebuttal to those comments?
Yeah, I was just going to say, Mr. Zandy, if you want any brief rebuttal, I've got about got 9 minutes for you. So go ahead.
Under 5. So I think I'm going to start with the easy stuff that council talks about, and I was writing notes as quickly as I could, and some stuff got by me in that presentation. Council talked about the testimony of Mr. Bryant's employee. I can assume that's Ms. Waymeyer, and that's the new girlfriend. So I think we can consider that declaration and give it the weight that it deserves. And in my opinion, that's not a whole heck of a lot. So that's first and foremost. We also talk about this notion of my client not being in the home as much as she was prior. And again, that goes back to June. Council says we don't address that. We clearly do. And again, this goes back to what's happened since June. Yes, she has, as she tells you, looked for every reason to not be in the home when Mr. Bryant is there, because again, he's showing up at 1 o'clock in the morning next to her bed. He's trying to break down doors. He's intoxicated and impaired. So yes, she does not want to spend long periods of time with him. And given the circumstances, that's why this is important. That's why this is urgent. She absolutely disputes and disagrees that he was ever a primary parent. And again, contrary to what council states, and they're doubling down on this notion that he doesn't have any issues in the pictures. Well, those could have been manufactured or taken with somebody on the side of the road, or whatever the case may be. Again, that's highly unlikely. And we have pictures of, looks like 1, 2, 3, 4 different pictures of Mr. Bryant laying on the ground in a shed. One which appears he's on some kind of an automobile chair in a garage where he's hunched over, or some kind of dock bed. There's one where he's laying on, again, some kind of a hard surface from May. And then we have this one where he's awkwardly in a lounge chair. And my client shows you the pictures of the alcohol. To sit there and assume that this is a primary parent who's taking care of his kids when he's in this type of condition, I'm surprised by not only the declaration, but the argument too. That's just not what's happened. And again, that's in the purview of a GAL. A GAL can certainly look at that. We want Mr. Bryant to be involved. My client never said he wasn't. But again, to come forward and say, well, he takes care of the children. No, he doesn't. There's one child at issue between these parties. To suggest that he is the primary caretaker, does everything, again, is not accurate. My client details for you. Sure, he took the child to the doctor a couple of times because she was at work. She works a 9 to 5 banker's hours at the credit union. He works a 4 on 4 off. If the child is sick and he's home and he's sober, he should take the child to the doctor. That's co-parenting. That's what we would expect. That doesn't make him a primary parent by any intents and purpose. My client doesn't recall him coming home every night and putting the kids to bed, as he alleges. And again, it just doesn't make a lot of sense given the information that you have in front of you. And I'm very confident my client is not out on the side of the road taking pictures of various Coors Light cans, which appear to be right next to the feet of Mr. Bryant. If so, that is one heck of a Photoshop job that frankly I haven't seen. So that's kind of where it's at. Same thing with the domestic violence. Again, my client details for you. What happened the last several weeks is a form of domestic violence. He was charged with assault 4. To suggest from Ms. Gilmore that, well, there's no information showing that he's ever had any domestic violence issues. The fact that he showed up and fled on foot after he assaulted not only my client, but her friend, that's domestic violence. The fact that he's sitting there and causing destruction inside the home, that's a form of domestic violence. The off-putting comments and the conversations, that's a form of domestic violence. So again, we've given you information related to that. We'll give a lot more to the GAL when that time comes. But again, it's what are we going to do with this child? And my concern goes back to what I initially stated, which is we've got a 12-year-old child on the verge of puberty. Those are very important years. Who is witnessing dad act in the manner he is, knows about dad's new girlfriend, knows about the alcohol consumption, witnesses this regularly. And he's starting down as he gets into those very vital and important teen years to say, there's my dad. I'm going to model his behaviors because, as my client details for you, he's just kind of apathetic to it at this point. That's the normal. That's what he's seen men in his life do. And Mr. is not setting a very good example for this 12-year-old child. That cannot happen. This child should not see his dad impaired to this degree, to any degree for that matter. And the fact is we have example after example after example of that. And the fact that Mr. Bryant goes into Safe Haven and says, well, I've had one DUI back in 2016, but I was sober for a year, withholding information about what happened in June, withholding information about what he's doing on a day in, day out basis, withholding that information, and then gives you a declaration from his, as Ms. Gilmore says, employee, which is also the girlfriend, saying, well, I've never seen him drunk at work, and he talks about his kids, therefore I think he's a good dad. Again, that's just isn't anything that can be relied upon. Same thing with those calendars, that's a GAL issue. But for now, we're at a very important crossroads right now. And we've got to make sure that in our humble estimation, we take care of this 12-year-old child and limiting the contact, not eliminating it, but limiting that in some capacity to ensure that this child is not at dad's house when dad is tanked to the point of passing out in a shop in the middle of winter in December. That's what we've got to be concerned about. We also have to have some input from the GAL and my client alike on any future evaluations, because clearly Mr. Bryant was being far less than candid and forthright with the evaluators.
Understood. Okay, I appreciate you both being flexible with the court schedule, given where we needed to get this case heard on the court's docket. I will get as much of my written decision out to you by Friday morning. I'm not here at the court Thursday, so I'll get that out Friday, filed with the clerk. My guess is, based on my ruling, we'll probably have to reconfigure child support worksheets. But my thought was, I'll give you my ruling on the request for spousal maintenance and the base numbers for the child support worksheet. And then if we want to set a date to finalize the child support worksheets based on those initial rulings, we could certainly do that.
I think we should. Let's build in a presentation date for, my suggestion would be 2 Wednesdays out, whenever your honor's available. I'll draft those orders as the moving party once we get your decision.
Okay, so let's set you for a presentation November 29th at 9 a.m. And then certainly if there's small points of clarification or disagreement that we need to hear based on my ruling, we can hear that as well.
Thank you.
Oh, yeah.
I would just ask that we draft and circulate the GAL order before that if we can.
Yeah, that's fine. I'll get that to you.
Okay, great. Thank you. I appreciate it.
Perfect. All right. Thank you both.
Thank you.
All right. Have a good one.